So, okay, students, good evening once again, and we'll begin with the class now. I've gone through the homework that you sent me that via Google Classroom. So, I've gone through all the names, and my question is, why did others not answer the question? Well, just to remind you that even this exercise does carry marks in the sense that I will be assessing you even on class participation and how you attend to homeworks as well. So, well, without wasting much of time, we'll directly go to learn about insurance. And some of you now are already acquainted to the term because you did answer your questions that were given by way of homework. So, what is insurance basically? When we are talking with respect to the law of insurance, we are referring to insurance as a contract. Now, this insurance is a contract that is basically represented by a policy in which a policyholder receives a kind of financial protection or reimbursement against losses from whom? From an insurance company. Let me reiterate for you, what is this insurance? Or let me put it this way, why does a person take insurance policy? Now, any person who takes the insurance policy would be called as a policy holder. For what does he take it? To protect himself or the good, chattel, or whatever it is he's trying to protect. He assures himself that there is financial protection in case there is any risk or any losses, that has to be covered because of the loss or the risk that he incurs. Can you just mute your mic, please? I'll just mute you. Okay, thank you. Okay. So thereby he, procures an insurance policy, who the policy holder, to protect himself against certain risks or losses. Like, now what does this insurance policy, what role does it play? Now, any insurance policy that may be taken, it hedges against the financial losses or risks like that result from, say, for example, from accidents, injury, or property damage, and so on. It also, helps to cover uh, costs associated with any liability. It could be, for example, it could be legal responsibility or legal liability for damage or injury caused to a third party. So therefore, again, coming back to the question, what is this insurance policy or insurance as a contract? So insurance policy is a contract in which the insurer indemnifies another against losses from specific contingencies or perils. So if you see here, there are basically two parties. Directly, if you see, there are two parties, okay, on a basic level. The one who takes insurance, right? And the one who insures or provides the policy. So the one who takes insurance is the insurer, is the insured. Okay, and the one who provides the insurance policy, that is the insurance company, is the insurer. So what does the insurance company do or the insurer do? The insurer indemnifies another against losses. Another, in the sense we are talking about the insured, the policy holder. The company, insurance company / insurer, indemnifies the insured against losses from specific contingencies or perils. So as you already, I'm sure you know, there are different types of insurance. I'm sure you heard of life insurance, health insurance, auto insurance, that is automobile insurance, and so on. Next is, there are certain payments to be made as against the insurance policy. So therefore, the core component of any insurance policy is a premium, the premium that the insured pays to the insurance company. Okay, so therefore, this contract is a contract in which, the insured, that is, the insured may be an individual or even a company, who pays the insurance company, that is the insurer, in exchange for a financial protection or reimbursement of losses resulting from a particular event that is sought to be covered. What can the events be? Say fire, accident. All these are different events. Let me give you one example. Say there is a hotel or say a fast food restaurant. Okay, so the fast food restaurant, they take a policy in which they cover the employees from sustaining injuries, uh, which must injuries from say cooking with a frying a deep fryer, for example. Okay. So then again, if you talk about doctors or medical practice, so there is insurance that covers medical malpractice, which covers injury, sorry, injury or death related liability or claims resulting from the healthcare providers, that is, particular hospitals, negligence or malpractice. Likewise, even businesses have their own insurance policies and so on. Then you must have like while you were preparing your homework, you must have come across the term premium. Now, what is this premium? Even I, as I said earlier, also I use this word premium. So a premium is basically the price that is attached to the policy. It may be paid either monthly or sometimes the insured prefers to pay it on a yearly basis as well. So this is normally the amount or the price that is paid by the insured to the insurance company. Okay. So just having now thus set the perspective, let us now go forward and see what the slide says. Now, here we are talking about just as a general introduction that in life we inevitably come across failures. That is, it is but normal that there are certain incidents that are not within our control. So we come across failures or we hear stories of accidents, sickness, and the lows of human existence. We hear about miserable incidents of destruction of life, property. It could be, through fire or whatever. So, existence and sustenance of life inevitably involves risks. So, risks are normal part of life. So, such risks need to be covered and combated, that is, fought against in case of manifestation of such risks to avoid deprivation and degradation of human sustenance. So, to cover such risks, which have potential to hamper personal, individual, family, or corporate finances in the form of financial damage or loss to body or property, insurance is needed. And thus, this sector, that is the insurance sector, plays a significant role towards maintaining and building the society. How it tries to cover risks that are associated with human life, human sustenance, and everything related to human beings. So, risk is basically an exposure to peril or some danger. So, insurance risk means a threat or a peril that insurance companies have consented to cover up in case of occurrence of that apprehended or unapprehended risk or peril. Now, there are an eclectic range of happenings that are considered insurance risks. For example, death of a person is a life insurance risk covered under life insurance policy. A motor vehicle accident is an auto risk which is covered under auto or motor vehicle insurance. So, likewise, there are several other insurances that are existing, like, for example, fire insurance to protect against fire. Then, insurance sector companies comprises of companies that sell insurance policies and collect deposits in the form of premiums, which may be released at the culmination of the policy or at the occurrence of a particular risk which the policyholder seeks to cover. Now, it depends upon the type of the policy. Hello, something is wrong with my system. 1 minute. One minute. What are the features of risks? So how are risks examined to be insurable? So how would one, or rather, how would the insurance company determine whether they should agree to the application of insurance policy or not? So they would determine whether at all those risks can be insured. So for the risks to be considered as insurable, it must be of some value, it should be calculable and significant enough to be able to be calculated. The risk transfer must be within an affordable bracket. That means it cannot be an infinite amount. It has to be within it should be an amount that can be really calculated and should be within the affordable bracket. Next, risk sought to be insured must be characteristically straightforward and definable to the extent that it supports objective verification. Risk must be unintended and unassumable. Further, losses may be direct or indirect. Now, what are direct losses? Direct losses refer to destruction of property or person itself. And indirect losses refers to consequential loss as a result of a direct loss. So in case of damage to a third party, that refers to liability risk, where the loss is caused by the actions of the insured policyholder. So thereby, risks are uncertain and unintentional, where the concept of probability and possibility come to the fore. Now, how does this insurance work? What is the nature of insurance? So insurance is a risk management tool to hedge risks and losses. That is what we understood throughout the class. I mean, till now, that's what we understood, that it is a kind of risk management tool. It tries to cover risks. It tries to cover losses. It hedges risks and losses. So in the societal angle, the risk transfer mechanism of insurance works in a way that it collects premium, that is the fees that are attached to the insurance policy. It collects premium to pool resources and then disburse them to those who are part of the policy at the right time of the need. So this is from the societal angle. So how does it contribute towards the society? The insurance companies, what they do, they pool the resources, they collect it. So that leads to pooling of resources, pooling of all these premiums. And then it's kind of a mechanism. Just think about it. Just imagine. Think of all the insurance companies. What are they doing? They are, of course, granting insurance policies for a price, and the price is a premium. So they collect the premium amount. So it pools the resources. And when the time comes to release that amount, they start releasing the amount. So they pool at one time, they start releasing. So it leads to, from the societal angle, there is a kind of a risk transfer mechanism wherein it collects premium and then disburses them to those who are part of the policy at the right time of the need. Next is at the personal angle or private angle. So unfortunate situations are covered by insurance policies. It also operates as a pecuniary tool or a financial tool to combat or fight the blow of an unfortunate event that has impacted the life, body, property of the policyholder. So insurance schemes operate as bifurcated into social insurance schemes and private insurance schemes. So broadly, you can classify insurance schemes into two: social insurance scheme and private insurance schemes. Now, risk transfer is again a foundational precept of most insurance transactions, where in risk transfer, specific risk is comprehensively outlined and defined, and that defined risk is passed on from one party, that is the insured, the insurance policyholder, to the insurer, that is the insurance company, who covenants or who promises to take the risk by executing an insurance contract and binding the insured to the terms of the policy. The next factor to be understood here is that insurance policy coverage must be real coverage. So this let us understand with the help of a case law, that is Abode versus National Union Fire Insurance Company. In this case, the court observed that the expectations of coverage must be real and objectively reasonable. In assessing the reasonable expectations of the insured, the court will consider communications regarding coverage between the insured or its broker and the insurer or its agent that relate to insured's expectation whether the scope of coverage is so narrow that it largely nullifies the insurance and defeat the purpose for which it was obtained. And if the policy's unrealistically narrow coverage causes broad injury to the public at large, which requires the court to preclude enforcement on public policy grounds. So, therefore, insurance must be of real factors. Now, talking about risk pooling, the factor of risk pooling refers to the creation of a large group of similar risks. Next is the foundation principles of insurance. There are certain foundational principles of insurance. The underpinning principle or the bedrock of insurance is, of course, utmost good faith. That is a foundational principle or the underpinning principle. Now, the concept that we need to understand here is, as part of the foundation, one of the foundational principles of insurance is insurable interest. I asked you a question on this, I remember. So, insurable interest is used to describe the connection or the nexus between the insured and the subject matter of insurance. Such an interest exists when an insured person derives a pecuniary or a financial benefit from the continued existence of the insured object or suffers a financial loss from the loss of the insured object. A person is said to have an insurable interest in something when the loss or damage caused to the insured items would directly affect the person. So this is an insurable interest. That is a connection or the nexus between the insured and the subject matter. They check the nexus or the connection between the insured and the subject matter of insurance. So the insurable interest must exist, and it is a prerequisite for granting insurance policy. Now, all insurance policies are based on the concept of wager. That is a happening of an unknown event. That is called a wager. The courts have developed the concept of insurable interest to constrain the concept of wager, to appropriate it to a purposeful concept of legally covering pecuniary or financial losses. So thereby an insurable interest is a legal right to enter an insurance contract. A person or entity is said to have an insurable interest if the event insured against could cause that individual or a company a financial loss. For example, there is one Mr. A and he lives in a house and that house belongs to him. So he tries to take an insurance policy, say a fire policy, just because, say now, he also has a lot of parties, for example, in the house. He has a lot of barbecue nights and they are used to having these barbecues in the corridor, for example. And then he says there is a possibility that, there can be a fire accident. So then he takes a fire insurance policy and say, God forbid, once what happens, there was really a fire. So while disbursing the insurance amount or while granting while calculating whether there was a fire, there is a legitimate cause for the insurance company to disburse the amount to the insured, or even while he takes the policy, whether at all the policy should be granted to him. So the insurance company tries to see whether there is an insurable interest. Now, the insurable interest here is the house belongs to the insured. Say, for example, Mr. A. So the house belongs to A. He wants to protect his house from the fire, or from being destroyed by fire, or in case there is, he foresees the risk of fire. So therefore, he wants to protect the house from fire. So therefore, here there is an insurable interest. Why? Because the house belongs to him and he foresees that problem. He foresees, and therefore he wants to take a fire insurance policy and he wants to protect his property. So this is insurable interest. So an insurable interest fortified in a valid contract exemplifies the right of the party to claim for losses incurred which are covered in relevant insurance policy, which may be obtained by the insured. Now, in Hyman versus Sun Insurance Company, the court referred to the case of Farmers Mutual Fire Insurance of Georgia versus Pollock. Now, in this case, one of the observation of the court is being quoted here, where one of the judges said that other courts have looked at insurable interest with respect to property as whether the insured has such a right, title, or interest therein, or relation thereto, that he will be benefited by its preservation and continued existence, or suffer a direct pecuniary loss from its destruction or injury by the peril insured against. That means whether at all it directly uh, hampers the life or property of an individual who has sought the insurance policy. So to see the connection or the nexus between for example, the property that is insured and the person who's insuring the property. In short, Mayer versus NJ Realty Title Insurance Company, the court observed that the law's requirement that an insured or the beneficiary of the policy have a recognizably defined interest in life or property prevents socially discouraged wagering, arson, or other destruction of property, limits indemnity to actual loss, and reduces potential risk to physical well-being and life. The next factor is utmost good faith. So here, insurance contracts revolve around the principle of good faith. So it is necessary that all relevant material information has to be disclosed by both the parties to the contract. The party who proposes insurance has a legal obligation to disclose all material facts that are relevant to the subject matter of insurance. Next is insurance contracts are contingent contracts. Insurance contracts are based on extrapolation of an unforeseen event or apprehension of an unforeseen event, which may and may not be predicted. Thereby, they are referred to as contingent contracts. That is something that is dependent on unforeseen event or something that they apprehend as an unforeseen event. That is to cover unforeseen problems or issues. That is contingency, dependent on a contingency. They are contingent contracts. So principle of indemnity, or that's a principle of contingency. Now there is principle of indemnity, that is to make good the loss. Indemnity is to make good the loss. It refers to making good or compensating the loss incurred to the insured. So, however, the principle of indemnity does not apply to life insurance policy, but to every other policy. Principle of indemnity. Principle of assurance next. Principle of assurance is used in case of life insurance policy where the life insurer, that is a policyholder, pays a fixed amount as specified and as agreed in the contract. Such an amount is called as a sum that is assured. Thus, life insurance contracts come within the ambit of contracts of assurance. Principle of subrogation. Now, talking about your examination point of view, this is a very important question. The first chapter is very important examination point of view. So principle of subrogation. Now, taking over of the insured's right by the insurer is called subrogation. In simple words, when the insurance company releases the amount to the insured and the insured tries to make a claim elsewhere, for instance, to the court of law, then in such a situation, the amount of claim will be subrogated to the insurance company. That is the insurer to the extent of the amount disbursed or released the insured under the relevant insurance scheme. So this is the principle of subrogation. Next is principle of contribution. Now, the principle of contribution refers to the right of the insurance company, the insurer, to recover a proportionate amount from other insurance companies, that is insurers, under whose scheme the insured is covered. So thereby the insurers collectively under different policies contribute towards indemnifying the loss of the insured. Next is the principle of proximate cause. This is something very important. Principle of proximate cause. Now the concept considers the cause of the loss that is most proximate or most closest to the loss. The cause, like causation theory. We've got something as called as causation theory. C-A-U, causation. C-A-U-S-A-T-I-O-N. Just type it here in the chat box. This chat. No. Okay, never mind. I'm not able to type for whatever reason. So causation theory. So what is this causation theory? Cause. There's a word cause in this. Cause and effect. This is the causation theory. So here, the most proximate cause or the most closest cause. So they examine the cause and the effect. What is the closest cause to the effect that has taken place? The effect is, of course, the loss. What is the cause of the loss? So this is the principle of proximate cause. So it examines the causation and the nexus between the cause of the loss and the loss itself in order to conclude or to draw a conclusion on the disbursal of the insurance claim, so as to compute the insurance claim, to calculate the insurance claim and release the amount to the party. So if loss to an insured property is a result of two or more concurrent causes or has occurred in succession, such a situation mandates the examination of the most proximate cause or the most closest cause out of the several underlying causes of the loss. So claims in which losses are remotely connected to the cause under which the policy is covered would be rejected. Next is the law of large numbers. So the law of large numbers, as the name itself suggests, is an interesting principle and covers insurance policy collectively of a group of policyholders. This is also called the law of averages. So more clearly, as per the International Risk Management Institute, the law of large numbers refers to a statistical axiom which states that larger the number of exposure units independently exposed to loss, the greater is the probability that the actual loss experience will be equal to the expected loss experience. So this is the law of large numbers. Next is the principle of adhesion. Insurance policies are considered as contracts of adhesion and are construed liberally by the courts. Now, contracts of adhesion are contracts that are drawn without any right of negotiating the terms. There is normally normal contracts, we negotiate contracts, but when it comes to insurance contracts, there are lesser or no chances of negotiating much. Therefore, we call it as contracts of adhesion, and the insured must accept the terms of the policy. Next is principle of fortuity. Now, this principle implies that the inherent factor of any insurance bargain is to interchange a risk of future, probable, and impending loss for the certainty of the premium. Now, in Flommerfeld versus Cardillo, the court observed that an insurance policy is a contract enforced as written when its terms are clear in order that expectation of the parties will be fulfilled. As all contracts and laws are subject to interpretation to understand the spirit of the letter in the clauses, likewise, insurance contracts are interpreted by the courts of law in insurance cases. Insurance policies, being contracts of adhesion, are construed liberally. Contracts of adhesion are contracts that are drawn without any right of negotiating the terms, just as in insurance contracts, the insured has to accept the terms of the policy. Now, talking about regulation of insurance depends upon the jurisdiction, the nation, the area. So the laws depend upon the jurisdiction, the regulations depend upon the jurisdiction. There are various insurance laws, legislations, codes, and so on that are prevalent domestically, that is within the country, as well as we have international mandates which needs to be adhered to. Now, in Union Life Insurance Company versus Pyrano, the United States Supreme Court has observed that the business of insurance must meet a three-part test. One is the activity involves underwriting or spreading of risk, and the activity is an important part of the insurer-insured relationship. And three, the activity is limited to entities within the insurance industry. So therefore, we have learned today certain what is insurance, that it is a contract. We've given the just a simple introduction on insurance, the types, and moreover, we went through the principles. The basic principles of insurance contracts, the foundational principle is that it is dependent on good faith. The underpinning principle is the principle of good faith or the utmost good faith. Next is insurable interest, which is very important. Then we spoke about insurance contracts being contingent contracts at utmost good faith, principle of subrogation, principle of indemnity, principle of assurance, that is life insurance contracts. We spoke about principle of contribution, principle of proximate cause, principle of large numbers or the law of large numbers, principle of adhesion, because there is little or no chance of negotiation, the insured must accept the policy principles or the terms and conditions that are attached to the policy, principle of fortuity, and finally, we spoke about the regulation of insurance and an important case law here, that is a union labor life insurance company versus Spirino, where the United Nations Supreme Court spoke about business of insurance must have three factors involved as a three-part test. It must involve underwriting or spreading of risk. It must be an activity which is an important part of the insured relationship, and the activity should be limited to entities within the insurance industry. So now you can feel free to ask me questions. I don't know.